Alrighty, well, welcome everybody. Thank you for joining us today. My name is Andrew Doffany, and I'm the Instruction and Outreach Librarian at the New Jersey State Library. And it is my pleasure to present today Ryann Siclari and Nicolette Vasco from the Alzheimer's Association. Ryann Siclari is currently with the law firm Porzio, Bromberg, and Newman. In 2008, she received her Bachelor of Arts degree from the University of Alaska Fairbanks, and she also graduated from the Widener University School of Law in 2011. She obtained her Master's of Law in Elder Law in 2017, and currently her practice focuses primarily on the areas of elder and disability law, including long-term care, Medicaid, guardianships, and estate planning, including wills and trusts. Ryann is on the board of the Elder and Disability Law section of the State Bar Association and speaks regularly on elder law issues for both attorneys and the community. Nicolette Vasco has been on the staff of the Alzheimer's Association since 2016. She is the program coordinator and as such oversees delivery of all programs and services offered by the Alzheimer's Association to constituents in the greater New Jersey region. So I'd like to welcome both Ryann and Nicolette to today's program. Before we jump in, just a few housekeeping items to go over. First and foremost, we will be taking your questions, so please type them at any time in the questions box in your GoToWebinar dashboard, or you can email me directly. My email address is on the screen there. Today we have 5 handouts for you, including a copy of the PowerPoint slides, as well as some information about the Alzheimer's Association, as well as some facts about elder law in general. There will be a survey that will be available at the end of this webinar, as well as in a follow-up email. We always ask that if you can please complete the survey, that would be great. We always like to hear from you and hear what you have to say. I'd also like to mention that there is a part 2 of this session that's going to be May 25th from 12 to 1. That'll be covering what we don't get to today. So I believe we're starting with the legal stuff today, and then we'll talk about the financial stuff next week. And if you're looking for more information about Alzheimer's Association, maybe how to get involved, you can always visit the address on the screen, which is the web address for the Alzheimer's Association New Jersey chapter that Nicolette is associated with. So one last thing before we get started, just a brief overview of the GoToWebinar dashboard. And for those of you who may not be familiar with this is what your dashboard should look like if you're using either a laptop or a desktop. If you're using a mobile device, your dashboard is going to look different, but all of the features will still be there. If you do not see this dashboard, look for this orange box with a white arrow, either at the top left or right-hand side of your screen. That will open and close the dashboard, and the dashboard might have loaded closed on you. At any time, if you have any problems, you can use this raise hand button here, and that'll alert me. I will send you a message, and hopefully we'll be able to resolve any issues that you're having. I did mention that there are 5 handouts for today, so you can open up the handouts section here, and you can just click on each handout to download them. And as I mentioned before as well, there will be taking questions today, so please use this question box, type in your questions, hit send, and then we'll be happy to answer them throughout the program. So that is everything that I have for you. So I'd just like to turn it over now to Nicolette just to do a brief talk about the Alzheimer's Association.
Thank you, Andrew. Thank you for being a great partner. Thank you everyone for joining us today. And Brian, you're amazing, and we're so happy and privileged to have you. And I didn't know that you were in Alaska. That's very exciting and a new factoid. We are happy to have you here today. This is a very popular program because we have so many concerns about legal and financial planning, and as adults, things that we all should do, not just because we have a diagnosis of Alzheimer's or dementia, really things that sometimes we delay, but we will need to make decisions at some point, and possibly someone will need to make decisions for us. And what are those decisions going to look like, and do we have a say in them? And does that person know our wishes, and will they be executed as so? So really good, important topics, things to think about before we get to the point where they have to be executed. And we're so privileged to have a great elder lawyer with us today to explain those areas, because definitely not my area of expertise. But I'm here if you need any help with our Alzheimer's Association resources. We are here for you. Even in this virtual environment, we have a 24/7 helpline. We have support groups and education programs like this one. So please feel free to reach out at any time, and we're here to support you and your family and community. So I'll turn it over to Ryann.
Okay, thank you so much. So welcome everybody to part one of our two-part presentation, Legal and Financial Planning. And as Andrew mentioned, today we're going to talk about the legal planning part. And this program is really designed to help people in the early stages of dementia, their care partners, their families, to really understand the legal and financial issues that they're going to impact them, and how you can make decisions, put legal and financial plans in place to try and minimize the impact of these things on your lives. So while the information here is not intended to be a substitute for an individual consultation and plan regarding legal and financial issues, it's a good place to start, just to get the wheels turning, to have a better understanding about what you can do going forward. So let's get started. So this program was designed with some specific objectives in mind. So by the end of this program, we're hoping that you'll be able to understand the importance of advanced planning and have an opportunity to involve the person with dementia. So again, we don't want to be making decisions for this person. We want the person to be able to make some decisions for themselves while they're still able to do so. We want to identify the steps to getting these legal and financial plans in place. We want to become familiar with the specific legal issues and care options, and next time, the financial issues pertaining to dementia. And we want to give you some hands-on tools to start making these plans now, rather than waiting until they become critical and maybe losing some of our planning options. So what I'd like to start with now is a video showing an individual who has early onset Alzheimer's, meaning that his symptoms appeared before the age of 65. So he's going to talk a little bit about the importance of doing these legal and financial plans.
It appears that the audio is not working on the video.
Uh-oh, let's see here. Is there a way, Andrew, do you know, to get this audio? I know in Zoom there's a button that we can press. Is there a similar button here? And if the answer is no, I can just let you guys kind of know what he talks about.
There's no button, and I think it has to do because it's not connected to your microphone. Then so the microphone is what the audio is focused on.
Let's see here. Audio, computer audio, microphone. Here we go. Yeah. I'm sorry, guys. I don't know how to get that audio working for you. So basically, John here is just talking about how when he was diagnosed, that he was able to get these legal documents in place and make decisions for himself, so that he felt a sense of personal autonomy, that he was the one making these decisions, and it wasn't something where people were making decisions for him. He felt involved and important. So the planning, there are several reasons that we make legal and financial plans early in any disease process. So first, the legal and financial plans related to Alzheimer's disease in particular are complicated. So it takes time to become informed in order to make decisions that are appropriate to your particular circumstances. Also, by planning early in the disease process, the person with dementia has the voice. They're the one that gets to make the decisions about important issues. And finally, if families wait too long to plan, there can be some really difficult consequences, and we're going to talk a little bit about that today as well. So we'll start by discussing legal issues concerning Alzheimer's disease and related dementias. And then next week, we're going to talk about financial issues, including how to pay for long-term care related to Alzheimer's. We'll finish up with a review of some resources and some additional information that can help you kind of get started in handling this process. So the goals of legal planning. People make plans for a lot of different reasons. Having legal documents in place can help family members plan for long-term care and health care for the person who needs dementia care over time. Certain documents provide some direction and guidance on how to manage the person's financial affairs or medical affairs. Other documents appoint people to help make those decisions. But ultimately, the legal planning is intended to eliminate the guesswork. We don't want to leave our family and friends in a situation where they're wondering, well, what would my loved one have wanted? With the proper legal planning in place, the decision makers have already been decided. We know who's making decisions. It's clear from the legal documents what the decisions should be, and it makes the process as easy as it can be as you're going along with this. So the first legal document that we're going to talk about today are advance directives. So advance directives typically deal with end-of-life care, and really these are things that all of us should have in place, not just someone with Alzheimer's or dementia, but all adults 18 years or over should have these documents in place, because when these types of decisions need to be made, we really want to know what the person would have wanted, because we all feel differently about how our end-of-life care is handled. Knowing what the person wants spelled out in a legal document makes a very difficult situation a little bit easier, because we're so emotional during an end-of-life situation where, do we stop life-sustaining treatment? Do we continue life-sustaining treatment? What would the person have wanted? Knowing clearly ahead of time what this person would have wanted makes that process much, much easier. So an advance directive is a legal document that basically gives the person making decisions a clear guide regarding what kind of treatment and care the person would want in an end-of-life situation. There are really two types of two things that are being addressed by an advance directive. There's the durable power of attorney for health care, which essentially designates the person who can make medical decisions for you if you're unable to make them for yourself. This is called an agent. So it lists your agent, and we recommend successor agents. That way, if the person you list is not able to make decisions for you, you have backups listed. And then the living will. And the living will is a document that outlines the end-of-life care. So do you want life-sustaining treatment, such as a feeding tube, a ventilator, CPR? Those are types of things that might be listed in your living will. And many times, or at least here in New Jersey, we can combine these into one document. So you don't necessarily have a separate healthcare directive and living will, though you might. Most of the time, they're combined into one document. That way we can make it a little easier to keep track of these things. Another document that you may want to consider is called a physician's order for life-sustaining treatment, or a POLST, P-O-L-S-T. The POLST is similar to your advance directive in the sense that it deals with medical decisions and what you would want under particular circumstances. But the big difference is an advance directive and a living will are legal documents, whereas a post is a physician's order. So why is that important? Well, if you are home and 911 is called, they're not going to go looking at your living will. The post is a single page on a very bright colored green paper that you might stick to your refrigerator, somewhere very easily accessible. So in the event of an emergency situation, it's a physician's order. It must be followed by emergency personnel. So that's why it's on that bright colored paper, very easy to see, accessible location. But this is something, if you, for example, do not want CPR, you'd want that on a post because it must be honored by emergency personnel as well. These are typically done in situations where someone is seriously ill. So we want to make sure those things are in place, especially if you have strong feelings about things you would want as far as life-sustaining treatment goes. So another important aspect of medical treatment and medical records are your records with your doctor. So if you take a person with Alzheimer's to the doctor's office regularly, one of the things that you'll want to look out for at the doctor is whether they have their own HIPAA release. So HIPAA is the Health Insurance Portability and Accountability Act. And all that has to do with is privacy of your medical records. So if you're going to the doctor regularly with the person with Alzheimer's, you can make sure that the doctor has your information as an authorized person to give medical information to. And you would do that at every single doctor's office because that way each doctor has it on file who can access the medical records. But really, accessing the medical records is only a small part of this, because if you don't have the advance directive allowing you to be the person to make medical decisions, having access to the records only gives you information. It doesn't give you authority to make medical decisions for someone if they cannot make them for themselves. So a HIPAA release for medical records is only part of the solution to dealing with medical issues. The advance directive is the one that clarifies who can make the decisions about medical issues. So anytime we're talking about doing legal documents, we're talking about a person who has capacity to execute a legal document. So before I talk any more about documents, I really want to hone in on legal capacity. Because as a person with Alzheimer's progresses, they eventually get to a point where they no longer have legal capacity. They don't understand what they're signing. They don't understand the decisions that they're making about documents, care, finances. So when a person gets to that stage where they don't have legal capacity, they cannot execute these documents that we're talking about. And instead, you would have to have a judge determine that they are incapacitated. And we'll talk a little bit about what that is, is involved with that process. But when it comes to executing legal documents, it's typically an attorney's assessment. We would look at the person's ability to understand the document itself. Are they making logical decisions in their document? Are they naming their children as agents? Or are they naming a guy they met 5 minutes ago down as an agent? You know, we would look at things like that as signs of whether the person has capacity to understand the legal documents that they're putting in place. So ideally, the person who is creating these documents is doing it at an early stage of their diagnosis, because early stages, you're still more likely to have capacity to do this kind of planning. A diagnosis in and of itself is not enough to say someone does not have legal capacity. It's their current symptoms and state of mind. Do they, at the time they're signing the document, understand what they're signing? And if the answer is yes, then they would have legal capacity to execute these documents. But if you wait too long, they may get to a point where they no longer have the capacity to execute a legal document. And at which point then we end up going to a court process, which we will talk about shortly, called a guardianship. But if you're doing everything right, you're planning in advance, you're going to have a durable power of attorney in place. That way, while the person has capacity, that way you're not forced into this guardianship proceeding. So what is a durable power of attorney? Well, a durable power of attorney is simply a document in which you name someone else to handle your affairs on your behalf. So you creating the document are known as the principal, and the person you list as the person who can make decisions for you is known as the agent. So here in New Jersey, we separate these out. We have our healthcare directive, advanced directive that we talked about, but then we have a durable power of attorney for finances or property. And the durable power of attorney for finances, that's the one where you have the ability to handle the bank accounts. So you can write checks on the person's behalf. You can sell real estate on their behalf. You can close accounts and consolidate or open new accounts. This document is the one that allows you to deal with their finances. And in New Jersey, if you don't have a power listed, you don't have that power. So the power of attorney is probably one of the most important documents for a person who has a disease that is going to result in incapacity. Because, let me give you an example. For example, if you have income that exceeds the Medicaid income threshold, you're required to establish a qualified income trust to get Medicaid eligibility. We're going to talk a lot about that in part 2 of this. But if you have an incapacitated person who doesn't have a power of attorney, they can't establish this trust. No one has the legal authority to establish it. Or if you have a power of attorney, but it doesn't give your agent the authority to establish trusts, you're still in the same spot as if you didn't even have the power of attorney, because the power you need is not explicitly listed in the document. So I implore you to make sure that when you are getting these documents drafted, that you use an elder law attorney who's familiar with the long-term care needs of someone with Alzheimer's, to make sure that the powers that are needed are actually in the document. And when it comes to executing a durable power of attorney, we here in New Jersey only require that it be notarized. But as a belt and suspenders kind of thing, we usually ask for 2 witnesses as well. And the reason for that is because some states require 2 witnesses and a notary on their powers of attorney. So if you have your power of attorney done here in New Jersey with just a notary, and you move to another state that requires all 3, and you don't have it, now your power of attorney is no good in that new state. So as a way to make sure that if you were to move, you have a valid power of attorney, we always try to do 2 witnesses and a notary. But in some situations it's just not feasible, but a notary is the bare minimum here in New Jersey. So I know that my audio is not working for the video, so I'm gonna go to the video and just explain to you a little bit before I'm not gonna play it, but I'll tell you a little bit about what she's talking about in this video. And you can see at the top, it's talking about the importance of updating legal documents. And this lady basically moved to another state and decided to meet with an elder law attorney regarding her and her husband, who had dementia, their estate planning documents. And the attorney asks her, who's going to be your husband's power of attorney? She says, oh, okay, me. And then the attorney says, well, who's going to be your power of attorney? She says, oh my gosh, I was going to have my husband, but he has Alzheimer's. So, the important point of this video is basically It's not just planning for the person with Alzheimer's. We have to think about this planning a little more globally for the couple as opposed to just the person with Alzheimer's. So one of the things we talked about a little bit before, but I'll get into a little bit more detail here, is the living will. And as I said before, the living will is the document that specifically outlines your end-of-life wishes. So this document comes into play when you are terminal. There's no chance of recovery. 2 doctors certify in writing that you have an irreversible illness or you're near death. And at that point we say, okay, well, what life-sustaining measures did he or she want? And in the document itself, it'll say, I do not want artificial feeding tube. I do not want a ventilator. It'll specifically outline your end-of-life wishes. So this is not a document that comes into play if you're just having an appendix surgery. This is you are in a terminal state and there's no chance of survival. What are your wishes? And again, this is another document where it's really important that the person with Alzheimer's gets to articulate their wishes before they're not able to articulate their wishes anymore. And they would do that in this living will document. So there are a couple other legal documents. So we talked about the living will advance directive for medical issues. We talked about the durable power of attorney for financial issues. Again, all those documents are, you're alive, but incapable of making decisions. But we also have documents that we should consider when we pass away. So the last will and testament comes into play only when the person passes away. And it does a variety of things. It names the executor, so the person who can manage the affairs, financial affairs when the person passes away. It names the beneficiaries, so who can receive the assets when someone passes away. And the will is, I would say, even more important if you have a couple and we're talking about the spouse who is well. So we have our spouse who has Alzheimer's, but then we have probably a well spouse, someone who's not sick. We want to make sure the well spouse has really good planning, because the last thing we would want to do is leave everything to our ill spouse and subject it to all their costs of long-term care when we can do some planning via the well spouse's will. So again, going back to that video that we weren't able to watch, the planning is not just for the person with Alzheimer's, but we're talking about global planning for the couple. Another document to consider is a revocable living trust. Now, this trust is something it's not for everybody. It is not a requirement. It is something that is useful for some people. So it really comes down to your particular circumstances and the consultation that you have based on your particular circumstances. But for some people, a revocable living trust makes sense. And a revocable living trust is basically a substitute for your power of attorney and your will. You'd still have your will and your power of attorney, but the living trust is a substitute for those documents because it allows you to essentially title your assets to this trust. So instead of my checking account being in the name of Ryann Siclari, my checking account would be in the name of the Ryann Siclari Trust. And I would have a trustee named. So a trustee is merely a person who can manage trust assets. So the trustee, while I'm alive and healthy, might be me. But I might have a co-trustee with my child because I may be not completely able to handle all the financial things. So myself and my child are co-trustees to manage these trust assets. Basically, like a power of attorney, gives your agent the authority to handle your assets. The trust document gives your trustee the authority to handle trust assets. It's a very similar idea, just a little bit different operation. But the trust gives really detailed guidance and instructions on managing the assets. The power of attorney is a little less structured in the guidance on how to handle things. And you can be very specific in your living trust and detailed on how you want things to operate. But it can include, you can title bank accounts, you can title real estate, you can title a whole variety of assets to the trust for control by the trustee. And one benefit of it is it does avoid anything titled to the trust, avoids probate. You don't have to go through the probate process when the person passes away. But here in New Jersey, the probate process isn't terrible. So you've got to really have that individualized consultation to see if that's something that should be very important for you. And like a will, the trust says who receives your assets when you pass away. So it's just, I talk about it because it's one more tool in the toolbox. Our toolbox has our advance directive and living will, our power of attorney, our will, and it also can contain a living trust. So we just like to mention it because it's out there and you should know that you have these options. So when legal documents are created ahead of time, while the person with dementia, can still make decisions, chances are better that things will go smoothly when the person needs more decision-making help. Someone will have already been appointed as their agent to make decisions, and their preferences are known. We know what kind of decisions to make because they're outlined in these legal documents. But inevitably, people with Alzheimer's or dementia will reach a point where they can no longer make decisions on their own. And, in some cases, these documents are not in place yet at that time. And if that's the case, we don't have a designated person necessarily. It's really helpful to make these decisions as a team, because that's really it. Most of the time, it's not just one person who's helping a person with dementia. It's usually a whole family, a whole team. We call it a care team. All those people who love this person and want to help them make good decisions. So, again, it might be family members, caregivers, the person with dementia, to the extent that they can express their needs and wants, should be involved. Because, the reality is their needs are going to change over time. So having an ongoing discussion makes a lot of sense. And sometimes physicians can work with the care team as well to help make decisions. And the reality is the family members and loved ones want to make the right decisions. They care about this person. What I think is the right thing might be different than what my sibling thinks is the right thing, but we both are coming at it out of the goodness of our hearts. And that can make it really hard when we disagree on how to do something, because we both feel really strongly that we're doing the right thing. So in those situations where you cannot come to an agreement and there's no real designated, this is the person who makes these decisions, it can help to get a mediator involved. At that point, they can just help you see it from the other person's perspective. The mediator is sometimes they're a lawyer, sometimes they're just a trained mediator, but their whole job is just to help you come to a mutual decision. They're not there to make the decision for you. They're there to help you, guide you to see each other's sides and help you come to a mutually agreeable position. There are mediators in the state of New Jersey. Like I said, some of them can be attorneys, sometimes they're not. But there are, you can go see the Alzheimer's website to see a list of mediators if that is something that you need to look for. But if you are at that point where you can't come to a decision, you've done mediation, mediation isn't helping you reach a resolution, and nobody has the authority to make a final decision, you may be in a position where you need to head to a guardianship. So a guardianship is sometimes called a conservatorship in other states, like California calls it a conservatorship. We here in New Jersey call it a guardianship. And we do have a conservatorship here in New Jersey. The difference is in a guardianship, we are determining that a person is incapacitated and incapable of making personal and financial decisions. Whereas a conservatorship, they are voluntarily having someone handle their affairs. So there isn't a determination of incapacity. So that's the big difference. And I honestly, in my career, have rarely seen conservatorship done in New Jersey. It's usually because if you need a conservatorship, you're more likely to just do a power of attorney. But when it comes to a guardianship, this is a situation where the person is incapacitated. They don't have the legal documents in place, and they're no longer have the legal capacity to execute those documents. And now we need a court to say, this person is incapacitated, and we're naming a guardian who's the person who can assume control and responsibility for the person and property of the person with dementia. And it's a process here in New Jersey. So here, when you need a guardianship, it's usually an urgent situation, but it takes time. You've got to get 2 doctors to certify in writing that via a specific report that the state of New Jersey has issued, stating that the person is incapable of managing their affairs. Once you have those doctors' certifications, you have to file legal documents with the court to start a guardianship proceeding. From there, the court will appoint an attorney for the incapacitated person, because the court wants basically a neutral third party to interview the incapacitated person, interview their families, and then they make a written report or recommendation where they state if they believe that the person is incapacitated, and if they believe the person who is applied to be the guardian is an appropriate guardian for that person. And it can be that simple if there's no disagreement among family members on who should serve, or if there's no disagreement about whether the person is in fact incapacitated. It can be more simple. As soon as you have family members fighting over who should be appointed as the guardian, now it's a mess, because now we have child 1 with an attorney, child 2 with an attorney, mom has an attorney. We've got 3 different attorneys charging all these legal fees to determine if mom is incapacitated, and usually, more importantly, who is going to serve as that guardian. If mom had just done a power of attorney when she still had legal capacity, we wouldn't necessarily be in this guardianship proceeding. So the moral of guardianship is you can avoid it most of the time by proper estate planning. And I say most of the time because sometimes there's a power of attorney in place, but the person's acting improperly, or mom is refusing to cooperate, and we really need a court order or court involvement in order to address the needs that she has, such as placing her in a nursing home against her will, so to speak. It may be an appropriate resolution, but if she's not willing, the power of attorney may not be enough. So, there are situations where you're forced into guardianship even with proper legal planning, but 9 times out of 10, you can avoid it. So that is guardianship in a nutshell. So another important aspect of legal planning is a situation where you have like a life partner, someone who you are in a long-term relationship with, but you're not legally in a recognized marriage. And that could be whether you've just had a long-term boyfriend or girlfriend and you just never married and just don't have the intent to do so, or you're in a same-sex relationship and you haven't married. or you're in a state that has certain recognized relationships that maybe aren't recognized in the state you're currently in. So there are situations where that occurs that it makes it even more critical to have the legal documents in place, because if you are not in a legally recognized relationship, then that person can't make decisions about your health care or finances, even though if, you know, under normal circumstances, they would have some ability to do that. Couples not in legally recognized relationships are substantially more vulnerable to the limitations regarding the ability to make decisions for each other without the proper legal documents in place. So if you are in a situation like that, where you're not in a legally recognized marriage, there's some tips for these types of committed couples to do in order to make sure that their decisions about who to make these kinds of decisions for them are honored. So it's important that if you have the legal documents in place, that you keep them in a safe, accessible location. That way, either of you can access it if you need to make decisions for the other. You can show the healthcare personnel that you have the legal authority in writing to make decisions for that person. And again, every state is different. So if you're traveling, you're going to want to make sure you bring these documents with you, because if you live in a state that doesn't recognize a relationship that you have, you want to just make sure you have access to the documents when you're traveling so you can use them if you need to. You know, many hospitals, especially now, restrict visitation, and they restrict it to only immediate family. And a lot of times immediate family is defined as biologically or legally related. So a long-term relationship is simply not going to be enough under the hospital rules. So to avoid that, to avoid the person being denied any kind of visitation rights, you know, you can have it, number one, have it in your legal documents. But you can also, if you have a particular hospital that you know would be the hospital that you would end up at if something happened to you, then you could even try and get on file an authorization of who can visit you if you're hospitalized. And the hospitals would be able to provide those forms for completion. And lastly, it's really important that you share your decisions with your family. So if you have in your advance directive listed your longtime partner instead of a child, you want to give them that information ahead of time, because it can come as a shock if they expect to be named and they're not named. You know, you want them to hear it from you, the decisions that you've made, to eliminate some of these controversies and, you know, hopefully eliminate people pursuing guardianship unnecessarily too. So we have covered a lot of information today, and I know I have some, I'm wrapping up a little bit earlier than anticipated, I think because of a little bit of the video issues, but I do have a few like tips for getting started in putting these plans in place. So first, you should gather the documents you have in place. If you already have a will, a power of attorney, a healthcare directive, get them together, get them reviewed, because if they've been done a long time ago, they may need to be updated. For example, we talked about the well spouse planning in a different way than maybe they did before their spouse had Alzheimer's. So just because you have the documents in place doesn't mean that they shouldn't be updated based on the status, the medical condition status. So gather the power of attorneys, gather the wills, gather the living wills, and then you can make a better determination about, are we missing anything? Do we need to have updates done? You know, there are do-it-yourself options online, you know, LegalZoom or office supply stores. I would discourage you from doing that, because I've seen a lot of these documents where they don't have the particular powers we need, for example. The power to create a trust is a big one that I spoke about that we really need in these documents. And I've seen it time and time again where it's not there and we have to go through a guardianship because we don't have any authority in the power of attorney itself. So the online and do-it-yourself documents are typically insufficient for a good, robust legal plan. And I hate to say it, but a lot of times they're actually wrong. Even though they say it's for New Jersey, my experience has been that they are, in a lot of times, you know, they will have missing witnesses or incorrect notary statements. So I discourage you from doing them online yourself. What I would encourage you to do is speak to an elder law attorney. And I say elder law attorney because there's a lot of attorneys out there, you know, general practitioners, people who do some estate planning, but don't have the experience necessarily with dealing with long-term care issues. Whereas like an elder law attorney really has a lot of experience in that particular realm. So one of the websites on the screen there is NAELA, National Academy of Elder Law Attorneys, NAELA.org. That will give you a list of attorneys you can put in your state, in your location. It'll give you a list of attorneys who are members of this organization who are more likely to have the expertise in the elder law arena that you would need with a long-term care issues that may arise. So there are also, you can reach to lawhelp.org, and then the Alzheimer's Association also has their 1-800 number as well to get some advice on how to get an elder law attorney to assist you. So with that, I have my contact information is up on the screen here, and I am happy to take any questions about the legal side of things. As we said early on a couple of times, we are having next week for an hour from 12 to 1. We are also going to have a similar talk about financial issues related to Alzheimer's. And, you know, we'll talk about Medicare and Medicaid and the cost of long-term care and what options we have in that regard. So I would encourage you to attend that one as well. So if there's any questions, please put them in the chat. Otherwise, I'm happy that I got to speak to you all today, and I look forward to speaking to you next week as well.
Thank you, Ryan, and thank you, Andrew. And if there's any questions, we'd be happy to take them in the next few minutes. And as I shared at the beginning, if there's anyone that joined us that missed the intro in the beginning, is that at the Alzheimer's Association, we have a free 24/7 helpline. It's 1-800-272-3900. It's one of the flyers that Andrew included in the handout. Someone's always available, so they can help if you have any questions, any crisis, any information that you need assistance with. It's translated in hundreds of languages, so definitely we're available to help serve all those communities. And we hope that you join us next time. If you need any support or other educational programs, please feel free to join us and call our helpline, and they can tell you all those possible opportunities that you can join. We are in New Jersey virtually presenting right now, but we will be shortly coming back in person and virtually. So a multitude of options so that you are feeling safe in your community and getting that help you need.
Yes, if anybody does have any questions, please feel free to submit them in the questions box. And we can give it a minute to see if any come in. All right, Ryan. Well, it looks like you did a fantastic job today.
I say I always like it when there's no questions, because it just means I did such a good job explaining everything that nobody had any questions.
So great. Well, looks like we don't have any questions, so we can go ahead and end part one there. I'd like to thank you, Ryan and Nicolette, for joining us today. I'd like to thank our audience for attending. There is a part two, as we mentioned before, next week, so please, if you have not registered for that, you can do that on our website. And I'd just like to end with everybody, be safe, be well, and hopefully we can see you soon.
Thank you, everybody.